even if they're not there. Okay, so we're continuing this week with our treatment of the criminal justice system, and we're focused really on the aspects of that system as it pertains to prosecutions, okay, and to be even more precise, the rights of the defendant versus the discretion given to the prosecution in a wide variety of matters. And we had spent a good deal of time in the previous class meeting just sort of laying out the basics, right? We just took a quiz, and he had several questions on that quiz that dealt with the amendments. I think it's really important for you guys to know the amendments. I think it's important to know that the provision about searches and seizures and search warrants is in the Fourth Amendment. I think it's important to know that the provision against self-incrimination is in the Fifth Amendment, and so on. So if it seemed like that there was some emphasis there on just remembering, like an amendment number or something like that, I guess so. I guess that's one way to look at it. I try not to have too much of an emphasis on that in these courses, on memorizing things, but I do think that this is the kind of information, that specifically is the kind of information that you should be able to recall or just kind of know, if not intuitively know by recall. Okay? So where we left off last time was we were talking a little bit more detail about the exclusionary rule. And I had told you that the court originally, the Supreme Court, I just a lot of times just say the court. You'll understand when I do that for the purposes of this discussion, I'm talking about the United States Supreme Court. It had originally developed that rule over 100 years ago in Weeks versus the United States. We didn't go into any real detail on that case, just sort of laid out the basics of it, which is the most important thing to remember is that is the origins of the exclusionary rule, okay? But we said that it took a half century because that original case, remember the provisions of the Bill of Rights were understood originally to only limit the authority of the national government, and that would include the provisions of the Fourth Amendment and the search warrant requirement, right? So the fact that that Weeks case in 1914 dealt with federal law and federal law enforcement didn't really answer the question about whether it should be applied in cases arising under state law. And that's an important question because if you didn't catch this point last time, I just kind of made it very quickly. Most criminal cases arise under state law. I mean, obviously there are federal crimes, but the real overwhelming majority of cases, I don't have the percentage. I used to, I guess, probably have some notion of what it was, but I've forgotten. An overwhelming percentage of, cases that arise, criminal cases, are arising under state law. So that's a very important question. Does this exclusionary rule only apply in federal cases, or does it apply in state and local cases arising under state and local law as well? And that was the question that the court had sort of avoided to a large extent for several decades. But as a result of its decision in Matt versus Ohio, we get the definitive answer. And the answer is yes, it does apply, right? And it is an extension of the Fourth Amendment's provision against unreasonable searches and seizures and the requirement for search warrants to the states through what provision of the Constitution? Through what provision of the Constitution applies that against the authority of states and local governments? If we know the original intent of the Fourth Amendment, like the Bill of Rights generally, was to limit the national government, that requirement against unreasonable searches and seizures, the requirement of search warrant would have originally applied to national authority. Through what provision of the Constitution does it apply to state and local as well? Well, there was a question on the quiz you just took. Hopefully you remembered that it was the 14th Amendment due process law clause.
Oh my God. Just answered the question that I was all like, yes.
Okay? All right. So that's about where we left off last time, although I think we had just started to scratch the surface on some exclusions to the exclusionary rule, but it occurred to me after the class session was over last time that I'd left out a piece. So before I get back on track with the exclusions to the exclusionary rule, I want to go back and pick up that piece. I think this is an important legal principle that we need to understand in the context of this discussion. The fruits of the poisonous tree doctrine, okay? So let me go to that and give you kind of a description of that. Okay? So the exclusionary rule means that evidence obtained by the police illegally, for lack, just the quickest way to say it is illegal. In other words, in violation of the provisions of the Fourth and Fifth Amendment, okay, can't be used or introduced as evidence at trial in an effort by the state to obtain a conviction against the defendant, right? That's what the exclusionary rule means, right? It's going to be suppressed, okay? Never introduced at trial. If there's a jury, they're never going to hear about it, right? Presumably, if it's a trial without a jury, just a judge presiding over it, the judge has the capacity through his or her legal training to put that out of his head when rendering a verdict, right? Okay, so the fruits of the poisonous tree doctrine is the idea that if a judge suppresses evidence at trial, okay, is that going to allow the evidence to be admitted as evidence, not allow the information to be admitted as evidence at trial because it was obtained by law enforcement improperly? Subsequent evidence may be suppressed as well if the judge determines that it was the direct result of the police actions that led to the original evidence being suppressed. Okay, does that make sense? I'll even give you an example here. Best example I could come up with when I was writing this down. Okay. For example, suppose the police interrogate a suspect without properly administering the Miranda warnings. Now, we haven't systematically talked about Miranda yet, but you know, you had a good enough introduction to it from the program that we watched, right? So if the police improperly administer Miranda and in the process of the interrogation, the suspect confesses to the crime and also tells police where he has hidden physical evidence, on the basis of that statement, the police obtain a search warrant and seize the evidence. That part of it they do correctly, okay? But since the trial judge suppressed the statements on the grounds that Miranda was not properly administered, it is very likely in this example that the judge will also suppress the physical evidence that they obtained as a result of the statements made by the suspect, okay? Under the fruits of the poisonous tree doctrine. They wouldn't have gotten to that evidence had it not been for the statements that they illegally obtained. Now, we're going to talk about here in just a few minutes all kinds of exceptions to that, okay? But that's the general legal principle. And it goes all the way, it goes 100 years, goes back 100 years to 1920. Okay? And it was actually in this case, Nardone, where Justice Frankfurter, yes, that was his name, Justice Felix Frankfurter, coined the phrase fruits of the poisonous tree. So I'm not going to share the whole thing with you, but just to give you kind of a sense of how these things work, in a prosecution in federal court, okay, so this case arose under federal law, evidence procured by tapping wires in violation of the Communications Act of 1934 is inadmissible. So apparently the FBI, or whatever the law enforcement agency was, violated federal law by wiretapping someone's telephone. They had telephones back in 1920. Okay? This applies only to the intercepted conversations themselves. This applies not only to the intercepted conversations themselves, but also by implication to evidence procured through the use of knowledge gained from such conversations. Okay? So this is, these two cases, 1920 and 1934, are really the origins of that, the fruits of the poisonous tree doctrine. Okay? All right, so questions about that? Okay, I needed to get that in because, as I said, we had started last time talking about some exceptions to the exclusionary rule, and I think that at least a couple of them don't make complete sense unless we understand the fruits and poisons tree doctrine as well. Okay? So we had started with the good faith exception that was developed by the Supreme Court in 1984 in the U.S. versus Leon case. Remember kind of how I described this to you last time? We go from the 1960s down to the mid-1980s, and it's pretty clear what the trend of the decision, the overall trend of the decision of the court is, what the emphasis is. It is to be more protective of the rights of the accused, okay? But then 1984 marks a clear turning point. By this time, you have a majority of the court, which is either Nixon or Reagan nominees, okay? And there begins to be a pretty noticeable conservative tilt in the court's decisions. And the first of these came in U.S. versus Leon. Now, I reported that to you a little bit inaccurately last time. So, as again, it was something I was thinking a little bit about after the class session was over. So I decided to go out and dig up a extended explanation of this case. I like this particular explanation of the case because it is from a book by my former colleague, John Domino, who I used to have an office right next to when I was at Sam Houston State University many years ago. And we used to kind of sit around and talk about these cases. And this case in particular, I remember because it was one that he was researching for his book. Okay. And here's his description of this case. Right? Although the Burger Court, by the way, whenever you see a name, the whatever the name is, court, it's referring to who is the Chief Justice at the time, right? So this would have been when the Chief Justice was Warren Burger. Okay, that would have been, he was a Nixon appointee, so it would have been in the 1970s, okay? From the 1970s, beginning in the 1970s, okay? So although the Burger Court left the exclusionary rule developed in map standing, it legitimized a number of important exceptions. The most important of these came in the United States versus Leon. Proceeding on an anonymous tip of unproved reliability, police officers began an investigation into Alberto Leon's alleged drug trafficking. A search warrant was issued after several deputy district attorneys reviewed an affidavit summarizing the officer's surveillance. The searchers turned up large quantities of narcotics and drug paraphernalia. After Leon and co-defendants were indicted on federal drug charges, a federal judge granted a motion to suppress evidence on the grounds that the affidavit was insufficient to establish probable cause. Do you understand that point right there? So when the police go to a judge and ask for a search warrant, they have to establish probable cause, which means what? In other words, the judge is supposed to be skeptical, right? The judge is certainly not supposed to be a rubber stamp for the police and just give them search warrants whenever they ask for them, because the judge presumably is also there to protect the rights of the accused, right? So when the police go to ask for a search warrant, they're supposed to be able to say with a high degree of probability that what they're looking for, they're actually going to find, okay, where they say they're going to find it. And if that is not supported, then the judge is not supposed to issue the warrant. So what really happened in this case is, you know, they fill out the affidavit, they swear out the affidavit, and the judge signs off on it, issues the warrant. But in hindsight, the presiding judge at trial said, well, that information, that affidavit really was not sufficient to establish probable cause, so the search warrant should not have been issued.
Does that mean
Okay?
that they can be tried for what they did?
I'm sorry?
Then they could be tried for what they
Well, it's not that they can't be tried. Remember, that was an issue that we kind of took up after when we were watching that program. It's not that they can't be tried. It's that the state, the government, can't use the evidence that they obtained from the search. If they have other evidence, maybe they have eyewitness testimony, maybe they have some other kind of evidence that they want to go forward with trial, they just can't use this evidence, right? And any fruits of the poisonous tree that might also come about, right? So, in other words, the trial judge is saying that the magistrate who signed off on this warrant should have never signed off on this warrant. Okay? However, the Supreme Court is saying on this appeal, Leon's lawyers are arguing that because the evidence should not have been introduced at trial, if not for that evidence being introduced at trial, my client would not have been convicted. Therefore, his conviction should be reversed and he should be released from custody. Okay? But the Supreme Court of the United States denies that appeal, saying that it's not the police officer's fault that the judge made a mistake. They were serving that warrant in good faith. And so we're not going to punish the police because of a mistake made by the judge. And I suspect that the defense lawyers might argue, no, you're going to punish my client for a mistake made by the judge, right? But that's neither here nor there, right? I mean, obviously you would expect the defense attorneys to take a different view of that.
So that's been fixed, right?
What's been fixed?
Not fixed, but like say if that happens right now, like if they had a faulty warrant, they found stuff, they ended up trying you, like, so.
To my knowledge, if I understand your question, if a judge was to make a similar mistake in 2021, this was 1984, very similar circumstances, whatever the fact, let's just take these facts that are presented here and say they happened in 2021, the judge makes the same mistake that the judge made back in 1984, that law still, that case law that the court developed in Leon is still the prevailing law. They would say, no, it was a good faith exception to the exclusionary rule, that the police were not flouting the Fourth Amendment, the police were not, disregarding the defendant's rights. They believed that they were serving a valid search warrant.
Yeah.
Now, we hope that there aren't too many judges out there that make those kinds of mistakes, but they're human beings as well, right? And so they're bound to make mistakes from time to time. Okay? All right, questions about that? Notice, though, that Byron White, who wrote the opinion for the court, ruled that the exclusionary rule should be modified to allow the use of evidence obtained by police officers acting in good faith on a search warrant issued by a neutral magistrate, even though the warrant is ultimately to be unsupported by probable cause. White reasoned that since the Fourth Amendment contains no specific provision precluding the use of evidence at a defendant's trial, the exclusionary rule is not set in stone, but is purely a creation of the court. Thus, Leon established a good faith exception to the exclusionary rule. But as Justice White pointed out, there are limits to the good faith exception. The officer is reliant on the magistrate's probable cause determination and on the technical sufficiency of the warrant he issues must be objectively reasonable. All right? Further, if the magistrate who issued the warrant was intentionally misled by the officer, that's a different matter. The fruits of the search may be suppressed. And the good faith exception does not apply in cases where the magistrate acts as a rubber stamp or where the warrant is not based on probable cause or fails to specify the place to be searched and the items to be seized. And so presumably if Mapp versus Ohio were decided in 2021, if the police got a search warrant specifying that they were looking for evidence in a bombing case, and they went to Mrs. Mapp's residence and they conducted their search and they didn't find any evidence in the bombing case, but they did find pornographic materials, and they decided to prosecute her under local decency laws or indecency laws, whichever is appropriate there. Presumably the court would hold the same way that it did in 1961, that doesn't constitute a good faith exception because the warrant itself specified that they were looking for evidence in a bombing case and not in decency, matters of decency. That makes sense? Okay. All right, so U.S. versus Leon is a very significant case. Now, I want to mention a few other exceptions to the exclusionary rule. And some of these at least one of them, the first one, is going to probably seem pretty obvious and straightforward to you, but let's touch on it even though it may be, okay? Evidence that is obtained as a result of a search by law enforcement who are in hot pursuit is not to be excluded at trial, or doesn't have to be excluded at trial. So what do we mean by hot pursuit? Hot pursuit is pursuit by law enforcement officer with or without a warrant for the purpose of preventing the escape or effecting the arrest of any person who is suspected of committing or having committed a misdemeanor or felony. Hot pursuit implies pursuit without unreasonable delay, but need not be immediate pursuit. Immediate pursuit is pretty straightforward, right? The police are pursuing a suspect. He ducks into his residence, locks the door behind him. Do the police have to stop what they're doing and go get a warrant? Well, apparently not. They can just bust in and place the person under arrest.
And sorry, can they, when they're coming for you, can they search your house and find, if they find anything in your house when they're coming for you, can they use that against you?
That's a good question. It's not one that I really think I have the answer for. I would suspect that the answer to that would be yes, based on other case law that I am aware of. I'm not aware of anything directly dealing with that question, but I think the answer to that would be yes. I'll give you sort of a personal example of that. I used to work for the city of Fort Worth in the city manager's office, and I went on, one of my responsibilities was overseeing the budget of the police department. And they would come to me from time to time as if they thought I had any decision-making authority. I didn't really. I just would write up reports for the city manager. But they wanted to take me on, they would come to me with requests for this equipment or that equipment or whatever, or new personnel or whatever. And I guess as part of that effort to butter me up or, make me so I'd be on their side, convince me of the earnestness of their requests and the need for their requests, right? They asked me to go along on a drug bust that they had planned. And they did their thing. They busted in and went through, and I was looking around with them, and it was they thought a crack house. This was back in the 1990s. They didn't find the drugs that they were looking for, by the way, but noticed some weapons that included, among other things, very large knives and can't remember, it's been so long ago, maybe a sword or something, but a set of brass knuckles, right? A set of brass knuckles, some other stuff that were kind of, and I asked one of the officers, I said, are those things legal? And he immediately grabbed them up, and they pressed charges against the owner of the home for possession of, there was a sawed-off shotgun as well. Okay, so I think that's the best answer, that I can give to that in that kind of situation, it's not really a hot pursuit, but, they did manage to come across some, it was probably within the scope of their warrant. Okay. Next is the inevitable discovery doctrine. Okay, so this one's a little bit more complicated. Hot pursuit's pretty straightforward. But this one is a little bit more complicated. It says that evidence obtained in violation of the due process requirements may not necessarily be excluded at trial if the government can show that it would have inevitably discovered the evidence by alternative law enforcement methods. This doctrine originates with a case called Arizona versus Fulminante. Very interesting case. which actually involved statements made, not physical evidence, but statements made by the accused. In fact, to be even a little bit more precise, it involved a coerced confession. The police coerced Arizona law enforcement. I don't know if it was the city of Phoenix or the city of Tucson or whatever, but police officers actually coerced a confession out of the suspect under physical duress. And when the defense attorney argued, and one would think that he would have every reason to believe he would prevail in this argument, that the statements made by the defendant confession were inadmissible at trial, the trial judge admitted the statements nonetheless that could be used by the prosecution on the grounds that the state was able to show that they would have inevitably discovered sufficient evidence to convict him by other means. That they had some search warrants lined up that they were ready to serve, for example, and they would have, if they had served those warrants, they would have obtained more than enough evidence to get a conviction. And so the Supreme Court said on appeal that those statements don't necessarily have to be suppressed at trial if the government can sufficiently make that argument. So this is a 1991 case, by the way. So here we are going through the 80s and 90s, and you can see that pendulum is really swinging now back in the direction of law enforcement pretty decisively. Okay? Next is harmless error. Okay? This was also a 1984 case. This is one that I kind of got confused last class meeting when I was trying to describe the Leon case to you. I was actually reporting to you the findings in the Massachusetts versus Shepard case. So let me share that with you real quick to correct the record completely. Okay. In this case, the Supreme Court held that evidence obtained by the police as a result of serving a search warrant in good faith is not to be excluded simply because the warrant is technically flawed. In the case, police officers used an incorrect warrant application form, then altered the form so that the judge would authorize the search. The judge authorized the search, assuring the officers that the necessary clerical corrections would be made. So you kind of have to use your imagination how this worked out. The police want to get a warrant. They pull a form out of the file. This is in the days before computerized things, right? There were computers, but the police department typically would not have had this kind of computerized process. So they reach into a file cabinet and pull out a pad of forms and scribble out the information, not noticing that they had gotten an incorrect form. They take that to the judge. They say, "Oh, judge, our apologies, we got the wrong form, but we really need to execute that warrant right away." And the judge says, "Okay, don't worry about it. My staff will fix it." Okay? But you have to understand, before 1984, and I think you saw this a little bit with the panel discussion that we were watching, the exclusionary rule was pretty much treated as a prophylactic remedy. That is to say that any kind of problem with the warrant would mean that it would automatically be excluded at trial. And that's a big part of what they were debating in that panel program is, should it be automatic? Well, here you have in 1984, in addition to the Leon decision, you have this case, Massachusetts versus Shepard, which said, we're not going to punish the police because the judge never got around to instructing his clerk to change the form. Or maybe he did, but the clerk did not do it, didn't execute that job function. All right? We're not going to punish the police. They were serving that warrant in good faith, and so therefore the evidence does not have to be excluded at trial. The Supreme, yeah, go ahead.
Just all these little things we got here sounds like they're really trying to get you. Like, doesn't it sound like they're getting the police more power to get you to be a little bit safer on the fact that they got you.
you know, I've said a couple of times that tried to describe it as a pendulum, you know, where from the 1960s through the mid 1980s, you kind of have the courts, the Supreme Court in particular, really sort of going the extra mile to protect the rights of the accused. And then beginning in the mid 1980s, you see the pendulum begin to swing the other way. But I didn't really offer an explanation to you for maybe why that, other than to say that the Supreme Court now had a pretty clear conservative majority. But I think beyond that, it probably merits saying that, you know, there was a perception on the part of many people in law enforcement and in the legal profession, certainly among prosecutors and maybe judges as well, and certainly in the general public, that the explosion in the crime rate that we saw in this country, beginning really in the late 1960s through the 1970s and through the 1980s, was a direct result of coddling criminals. There was this very widespread perception. I think political conservatives had definitely had a rhetorical edge in this debate over the rights of the accused. They would argue things like, see what happens when you coddle criminals, when you make it easy for people to get off on technicalities, you get the murder rate explodes, the violent sexual assaults explode, other sort of personal assaults explode, property crimes explode. There's no question that the crime rate in almost every category of crime grew dramatically from this very period that we're talking about, from the 1960s through the mid-1980s. It is also undeniable that on many indicators, the crime rate came down in the 1990s and through the 2000s and in the, you know, for example, the murder rate in most American cities, like take the city of Houston, is much lower today than it was in the 1980s. I don't know how many homicides you have annually in the city of Houston. I'm going to guess it's probably somewhere around 500, but back in the period that we're talking about here in the 1980s, it might have been up around 800 or 900. You know, I mean, it's just absolutely clear. What's not as clear is the cause and effect, right? There's, you know, lots of good room for debate on the cause and effect, but the fact of the matter is that in politics, the conservatives seem to have the edge in this argument. They were saying it's because of these lax decisions of the courts and coddling the rights of, they would probably say, the rights of criminals. I think more progressive people who are more politically progressive would probably say they're not coddling the rights of criminals, they're coddling maybe they're trying to protect the rights of the accused. Remember that in our criminal justice system, being accused of something doesn't make you a criminal. In fact, you are a citizen until you're proven guilty, right? With full protections. I think that's an argument that the conservatives, at least in terms of the political debate, prevailed on. Okay, good question though. Let's see, was there a point here we needed to touch on? Let's see. The Supreme Court reversed the suppression order, ruling that the error was harmless. And again, I think the defense attorneys would say, not to my client, but was harmless, and in any case was made by the judge and not the police. In a similar vein, the Supreme Court has ruled that the exclusionary rule does not apply when the police, through an honest mistake, find drugs while searching the wrong apartment, or where a computer error showing an outstanding arrest warrant on the wrong person leads to a search of a vehicle that turns up evidence used to arrest and convict that person. So there's another little caveat kind of to your question, Doreen, a circumstance where it might be. Okay, so questions about that? I don't know what I clicked on. Let me share this with you. From time to time, my practice has always been to share really the same substantive information with students in my online classes that I do in my face-to-face classes. Although it has been up until this semester, they're getting recordings of these class sessions now, but in the past, it's been in a little bit different format. So, from time to time, just like I get good questions from some of you in this class, occasionally I'll get a good question from a student in an online class on a discussion board. And so this is from the fall of 2014. Let me just share this with you. This is a student who asked me a question. I'm a little confused about the warrant process. If according to the exclusionary rule, a warrant has to be specific, how can law enforcement happen upon a crime accidentally and still use the evidence at trial? Are the rights of that individual not violated? And I think she was responding specifically to the discussion of this case that I've just shared with you, Massachusetts versus Shepherd, because I'd said in that discussion, that exact thing, that, about accidental, right? So I thought that was a pretty good question. I would have responded to her even if it wasn't a good question, but I decided to give her the most thoughtful response that I could because I thought it was a thoughtful question. So I said, well, keep in mind 2 points. Number one, there are a few areas of our law that are as murky, even for prosecutors and defense attorneys, as the rights of the accused, particularly the question of what the Fourth Amendment permits with respect to searches and seizures. You can get different answers to questions depending on who you ask. And secondly, I'm not a lawyer, and I don't pretend that I know the definitive answers to these questions, or her question in particular, but I did make my best attempt. Warrants are not required if the police observe a crime in progress. Everybody probably gets that, right? The police actually observe a crime in progress. They don't have to stop and go get a warrant, right? They're just going to make the arrest or attempt to make the arrest, right? Or in cases of hot pursuit. Also, the rules may differ when we are talking about arrest warrants as opposed to search warrants. I'm not sure if I'm answering your question very well. If not, perhaps she can be a bit more specific. And she was, right? So she follows that by saying that my husband, this is another student gets in on it before she responds. Another student who gets on it. Paula, the original student is Paula. Cynthia says, Paula, my husband, who is a criminal justice major, said that there's a plain view doctrine that officers go by. If law enforcement officers can see evidence of criminal activity prior to entering or in an initial search, then the officer has the right to enter without a search warrant. If an officer sees a weapon from a legal vantage point, he is allowed to proceed with a search. This is applicable to homes and vehicles. He looked it up in his book. No, actually that's a good point because, one of the things that we haven't really talked about yet is what spaces are subject to the warrant requirement. Well, we've been talking about it almost exclusively in terms of a person's home, but the home is not the only private place. There's not just a presumption of privacy at home. So, for example, if the police pull you over when you're in your car and they suspect that you have something in your trunk or the boot, as our German friends call it, right? Is that what they call it, the boot? Right? Can they just go, crank the boot open and have a search? Or do they have to go get a warrant? Well, obviously they can ask you, right? And if they say, hey, can we search your trunk? And you say yes, then they don't have to go get a warrant. But if you say, no, I don't think so, what do they have to do? Why do they have to get a warrant? Why can't they just bust it open and search it? Well, yes, because of the Fourth Amendment, but I'm trying to get you to be more specific. What is it about? Let's by contrast, let's say that they pull you over and in the process of coming up to your window, they notice that in the passenger seat you have illegal drugs. Okay? Do they have to go get a warrant in that circumstance? No, because as she says, it's in plain view. Right? See, the difference is, the question is there a presumption of privacy? Okay? If it's on the passenger seat in plain view for anybody who walks up to your window to see, there's no presumption of privacy. But if you put it in the trunk or the glove box and lock it away, there is every expectation that that's private. Okay? If you're in your home and you're doing something illegal, maybe indecent, let's say, and the neighbors call and complain, the police have come and observe, you have the curtains wide open, right? You're displaying for anyone who wants. There's no presumption of privacy there, right? Why can the police arrest someone for committing a lewd act in public, where they wouldn't be able to arrest them for committing the same act in the privacy of their bedroom? Because there's a presumption of privacy in the bedroom. There's not a presumption of privacy if they're doing it in public, all right? That's really the most basic thing that we said. So she's absolutely right, even though she got it from her husband who read it in a book, which is perfectly fine. Okay? But Paula really wasn't asking about that. So she says, I guess what troubles me is this ruling. And she's kind of quoting the information that I shared with you and I shared with that class. The Supreme Court also ruled the exclusionary rule does not apply to evidence that is obtained by honest mistake. For example, searching the wrong car or finding the evidence in the wrong apartment and searching the wrong apartment and finding evidence. I guess I should have asked, how can evidence accidentally be discovered, or how can evidence accidentally discovered be admissible in court, considering the specificity of the Fourth Amendment and the exclusionary rule? It seems to me if the Fourth Amendment states, and no warrant shall issue but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the person or things to be seized, then evidence accidentally found should be suppressed. What defines an honest mistake? That's what she really wanted to know. And so I responded to her. The answer to your last question is the presiding trial court judge must take into account the circumstances of the specific case and decide whether the police error was a willful violation or an honest mistake. That's the debate that some of the participants in the panel discussion were having near the end of the program. I'm certainly not defending the logic, but I think it goes something like this. The exclusionary rule was devised by the Supreme Court as really the only feasible means of preventing law enforcement from flaunting the requirements of the Fourth Amendment and willfully conducting warrantless or otherwise improper searches and seizures. If the evidence is accidentally found by the police as a result of the search of the property that doesn't even belong to the suspect they are investigating, the search could not qualify as a willful disregard of the Fourth Amendment. It would be more like the police just happening onto the commission of a crime in progress. Again, not a lawyer. Hope this clarifies. Well, she wasn't satisfied. Okay? The conversation continues. I guess more than a question, I was commenting on the accidental findings. I understand if a police officer happens upon a crime in progress. Let's say for the sake of argument, a bank robbery. It would absolutely go without saying that the police officer should act. However, what I was referring to was, let's say you're at home and there is a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house instead. Let's say you have in your home medical marijuana or whatever. How are they going to justify the lack of a warrant with a specific address and specific items to be found? I guess my point is that the person who happens to be searched because of a mistake has lost his right to the reasonable expectation of privacy, as the warrant issued does not include his address or the items accidentally found. She's being very thoughtful. Wouldn't you agree? It's kind of scary. Not that I would break the law, but tyranny is really ugly. And I'm concerned that this sort of thing could get out of hand. I know that there is not much a common citizen can do about that, but if I were the one to be invaded by the police by accident, I would be shouting my rights have been violated. That does not change the fact that I would still have to go through the whole legal process. If I am off base, I might understand this concept, please let me know. Okay, so here's my response. I think. There we go. What I was inelegantly attempting to suggest is this. The court seems to be mainly focused on whether the police willfully violated the search warrant requirement of the Fourth Amendment, not on whether the person who was not named in the warrant had his or her privacy violated. Right? That seems to be the concern of the court. Certainly not disputing your concern. I believe it's a valid one. No one is a greater proponent of the right to privacy. Well, that is true. In general, I agree with the assessment of Justice Louis Brandeis that the right to be left alone, that is the most comprehensive of rights and the most to be valued by civilized men. However, all of these cases in the area of criminal due process, indeed, in the broader area of civil liberties rights, ultimately come down to a matter of line drawing. Hey, we've talked about that point in here. Because the U.S. Constitution and the Bill of Rights are not crystal clear on these matters, in specific cases and circumstances, the courts have to determine where the line should be drawn between protecting the rights of citizens on the one hand and permitting the government the authority necessary to assert the state's compelling interest, maintaining order on the other hand. For most people, just a tweaking of the facts of a case can lead them to conclude the line should be drawn in different places. Consider a variation of your hypothetical scenario. I've pasted your scenario below and just changed a few words that are highlighted. Right? Let's say you're at home and there's a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house. Instead, let's say you have in your home a dismembered human body or whatever. How are they going to justify the lack of a warrant with specific address and specific items to be found? I guess my point is that the person who has so all the rest of that, all I did was take out medical marijuana and put in dismembered human body, and I suspect for a lot of people, that's very different. Right? See what I mean about the question of line drawing? I promise you this ends. Let's see how. I wonder how many people who might have agreed with your medical marijuana scenario that this person's privacy rights have been violated would now draw the line differently and conclude that this person's privacy rights are, if not irrelevant, at least secondary to the needs of the police to prosecute a murderer. And then I suggested some things, since she had some concerns about privacy rights. I suggested some things that lawyers typically suggest. I'm not a lawyer, but I have a good friend who's a lawyer, and these are the kind of things that he typically suggests to people. If the police come to your door with a warrant, and these things are hard to do, by the way, I think. Some people might worry that they're inviting some use of force against them if they were to exercise these rights. But this is the kind of things that lawyers say. Step outside and close the door behind you. If you leave the door open, officers are likely to blow past you to execute the search. Ask to read the warrant. Don't be satisfied with the officer just waving it in front of your face. If at all possible, insist on holding it in your own hands. Examine the warrant carefully to determine its validity. You should specifically look at the address indicated on the warrant, the date of the warrant, and the judge's signature. If the address indicated on the warrant is not your address or has a different apartment number on it, tell the officers that the warrant is not valid because the address on the warrant is 1234 Main and your address is 1244 Main, or that your apartment number is 406 and the warrant indicates apartment 416, and that you do not consent to the search. It is very likely that the officers will still execute the search, but now it will be harder for the police to claim that the mistake was a harmless error, that they made an honest mistake. If you put them on notice that they are making a mistake, the lawyers say, then you at least have a basis to challenge the harmless error or honest mistake premise. Okay? Asserting your rights may anger the officer, so be prepared for the police to take a more hostile posture toward you if you do so. Once again, not a lawyer, so be sure to ask an attorney if you have any reason to believe that you might find yourself in such a situation. Okay. Anyway, I thought that was not only an interesting conversation, but I think developed a little bit further the ideas that I was trying to share with the class, that class, and now this class, that stem from all of these, or at least from the harmless error exception to the exclusionary rule. Okay, a couple of others here real quick. Let's finish this up. Attenuation doctrine. So we've got here. These are exceptions to the exclusionary rule, just to go back and sort of put this in context. Circumstances under which evidence obtained in a manner that's not consistent with the warrant required of the Fourth Amendment does not necessarily have to be excluded at trial. Okay, so the first was the hot pursuit, inevitable discovery, harmless error, and now we're up to the attenuation doctrine. Okay. The attenuation rule provides that despite the illegality in obtaining evidence, such evidence may be admissible if the connection between the evidence and the illegal method is sufficiently remote or attenuated. Under the attenuation doctrine, evidence obtained after an unlawful arrest can be introduced if the connection between the police misconduct and the confession or the other evidence has become so attenuated as to dissipate the taint. That's the quote from the case law that characterizes the attenuation doctrine. Become so attenuated that as to dissipate the taint. The attenuation doctrine is an exception to the doctrine of the fruits of the poisonous tree. So maybe a hypothetical would be the police obtained a confession or obtained through the statements of the defendant or the suspect, they come to a belief that they're going to find some evidence if they conduct the search, but they fail to administer Miranda properly. Okay, and if Miranda is administered improperly or not at all, then even though we haven't talked about the Miranda case in any detail, we know that that statement is going to be suppressed at trial, that it's not going to be introduced as evidence by the prosecution. Okay? The question is, though, what about the search? Wouldn't that be considered fruits of the poisonous tree? After all, they learned of the evidence, the physical evidence, as a result of the statements. So whereas formally the fruits of the poisonous tree doctrine would have automatically kicked in, the attenuation doctrine says, well, maybe not, okay, and I don't know if we're talking about a matter of elapsed time or circumstance, maybe a combination, maybe either or a combination, whether the time that's elapsed is sufficiently attenuated or if the circumstances are sufficiently attenuated or some combination of the two. But if the judge reaches the conclusion that there is that attenuation and that the taint of the evidence that's obtained from the search is sufficient in circumstance or time or both, then it doesn't have to be suppressed at trial. It's kind of similar to the inevitable discovery doctrine in a sense, I think. Okay? Questions about that? The attenuation doctrine, and then finally, the independent source doctrine. The independent source doctrine says that evidence initially discovered during an unlawful search, but later obtained independently through activities untainted by the illegality, may be admitted into evidence. So maybe they execute an illegal search and find evidence, but later on they get other evidence, maybe eyewitness testimony or something that leads them to the same evidence, that it doesn't necessarily have to be suppressed. But, all right. So those are 4 or 5 pretty important exceptions to the exclusionary rule. Again, the broader point is Up until 1984, the exclusionary rule was just treated as a blanket application. If there's something wrong with the warrant, it's going to be suppressed. Beginning in 1984, through the 80s, 90s, and then now to this century, the trend has been, by the way, there have been recent cases that suggest even a further narrowing of the exclusionary rule. Maybe over the summer, I'll start investigating some of that case law so that in a future class, I can share that with them.
So you're saying basically the right time to be a criminal was before the 80s?
Well,
That's what it seems like.
maybe in a narrow window from the 1960s.
Darn it. Could have been the mafia, man. All right. Too late now.
You know, I don't think that we can, I don't know, this would be an interesting question to investigate. I don't think we stopped putting people in jail in the 1960s, or in prison in the 1960s and the 1970s and the 19. In fact, I think the prison populations increased during those periods. So lots of people. I think the real question is, for people who are really concerned about this debate, is in a specific criminal act where, let's say, you have a victim that the victim doesn't get justice because of the rights afforded to the accused. But again, the counter to that argument is, well, the Bill of Rights, these provisions of the Bill of Rights are not there to protect victims. They're there to protect the accused. Okay, anything else you want to ask about in terms of the exclusionary rule? Let's move on very quickly, see if we can get at least one more area in before we run out of time. A couple of cases here, we can deal with this fairly quickly. Right to counsel, okay, under the Sixth Amendment, you'll recall. One of the most important early cases came in 1964. Here's another one of those 1960 cases. Escobedo versus Illinois. This case involved a man by the name of Danny Escobedo. I think if I'm remembering correctly, his first name was Danny, who was being interrogated by police for many hours. And over the course of that interrogation, he repeatedly asked for his attorney. And he was denied access to his attorney by the police until he confessed. Ultimately, his will to resist broke down. I'm imagining like teams of detectives coming in over many hours, maybe several days. Tag team detectives, kind of like the first team comes in, they work on him, and the second team comes in, they work on him, etc. Right? Eventually, his resolve to stand firm to see his attorney breaks down, and he confesses. And on the basis of that confession, and by the way, solely on the basis of that confession, he was convicted of the crime. I think it was I don't even want to guess now. It's kind of, I've forgotten what the charges were. It doesn't matter. He was convicted. He appeals his conviction on the grounds that he was denied his Sixth Amendment right. The Supreme Court agrees that the police have to allow a suspect to have an attorney present, or they have to be allowed to consult with their attorney. Okay? This next case is actually a year before, Gideon versus Wainwright. It's actually a very famous case. Maybe some of you have heard of it. Do any of you like cinema?
Cinnamon.
Who likes cinema?
Oh, yeah.
Not cinnamon, cinema. Movies,
Yeah.
films. Yeah.
Like the
Do you like films from the golden age of Hollywood?
What is considered the golden age?
Classic films.
Oh, yeah, yeah.
It's not what I consider. I think it's what the
Like
Are you talking about 60s?
film critics consider. What?
What year?
Black and white.
This I think was a black and white movie. Anybody ever seen the movie Gideon's Trumpet? Won an Academy. You've seen it.
Yes.
Oh, and whoever's online, who's online? Is that a meme?
You know, I mean,
Yes.
Hey, tell us, Christopher, what it's about. How long ago did you see it? I don't want to.
In high school.
Okay. Oh, they still have students watch this film.
In my government class, we were learning about this case, and then after we were done learning about it, we watched the movie.
Did you enjoy the film?
I don't really remember much about it.
How about you, Amin?
I don't remember much. It was from high school, but it was a pretty good movie.
Okay, yeah, it won an Academy Award. Starring Henry Fonda. I don't know if that is an actor that registers with you guys, but too old, I guess. Father of Jane Fonda. I don't know if that's too old. At any rate, forget the Hollywood version. There's a reason that Hollywood made a film out of this story, okay? Because it's very interesting, okay? This case involved a man by the name of Clarence Gideon, who was a petty criminal, okay? I think his gig was breaking into pool halls and stealing the change out of vending machines, cigarette machines. You know, in those days they sold machines from cigarettes. I don't think they can do that anymore. I think that was part of the settlement with the tobacco companies back in the 1990s. But, you know, I'm old enough to remember when you could go to a grocery store and out in front of the grocery store there would be vending machines that sold cigarettes. You guys have never seen those in your life. But they would get a lot of change that would accumulate them, and that was his gig. He would bust into the pool halls at night after they closed, and he would steal the money out of the vending machines. Well, he was ultimately caught and arrested, put on trial, and convicted. And he asked, this occurred in the state of Florida, he asked prosecutors in the state of Florida to provide him with a defense attorney, and they declined, arguing that that was only something that was provided in death penalty cases. That was the policy in the state of Florida. And so he's convicted. He doesn't have an attorney there with him to represent him at trial or in pretrial or anything like that. He prepares his own defense, and he is convicted. He's sent to prison. Now, the interesting twist to his story is that he wrote his own appeal from his prison cell, sent that off to the Supreme Court, and the Supreme Court agreed to hear his case. And in 1963, they reverse his conviction, holding that the state of Florida has to provide a defense counsel. If the defendant cannot pay for the defense attorney himself or herself, the state has to do it. Okay, so that's the significance of this case. I don't think it surprises anyone here. Nobody's learning for the first time that if a defendant can't afford to pay for, in fact, they even say that in the Miranda warnings, right? If you cannot afford an attorney, the state will provide one for you, right? Okay, so that comes from the Gideon case. All right, so those are the two big cases that apply to right to counsel, but there are a few other cases that the court has decided along the way dealing with the right to counsel. I'm going to end on this one here because we've only got about 30 seconds. This case, Minnick versus Mississippi, 1990 case. The state of Mississippi essentially took the position that they only had to allow, to be compliant with the court's decision in Escobedo, that they only had to allow the defendant to consult with his attorney once. Okay? And if they wanted to question the defendant after that, they were free to do so. And that's what happened in this case. The police interrogated the defendant on numerous occasions after he had initially seen his attorney, and on the basis of information that they got, obtained a conviction. The conviction was reversed, and the Supreme Court of the United States held that the right of the defendant to have an attorney present during an interrogation holds until, once they invoke it, it holds until they waive it, which had not happened in this case. All right, we're out of time. We will finish this up on Thursday.